He's pleading no contest today to true indictment 2014 GS 463106 for the offense of peeping Tom. This is a negotiated plea for a negotiated 18-month sentence with credit since June 6th of 2014.
All right, Mr. Cousar, I have some questions for you. First of all, how old are you, sir?
23.
And before you were incarcerated, what did you do for a living?
I would help my brother-in-law
I'm sorry, can't hear.
clean the
You
house.
got to speak up a little bit for me.
I would help my brother-in-law clean the houses and stuff.
All right, how far did you go in school, Mr. Cousar?
Ninth grade.
How far?
Ninth grade.
All right. Now, do you understand what you're charged with today?
Yes, sir.
Have you and your lawyer been over the charge and all the elements of the crime, that kind of stuff?
Yes, sir.
So you understand, if I were to max you out upon my acceptance of the plea, you could get up to 3 years in jail. You understand that?
Yes, sir.
All right. Understanding what the charge is against you, as well as the maximum punishment you can receive, your lawyers indicated to me that you wish to plead no contest. Is that correct?
Yes, sir.
All right. Now, do you understand what a no contest plea is?
Yes, sir.
Tell me what you think it is.
Like you really ain't saying that.
Okay. You're not, that's correct. You're not contesting the charge against you. It's not an admission of guilt, but you're just not contesting it against you. Do you understand that?
Yes, sir.
Okay. But you understand for sentencing purposes, though, I treat it as if it were a guilty plea. You understand that?
Yes, sir.
Okay, thank you.
If the state had gone to trial, we would have presented evidence that on June 3rd, 2014, at approximately 12:30 a.m., police were dispatched to 630 Arch Drive, which is located within Rock Hill, within York County, South Carolina, in reference to a peeping Tom. The victim would have testified that at about 12:30 a.m., she walked down the hallway and was standing by the microwave close to the back door. When she looked, and within feet of her, at the back window, contained in the back door, was the face of a man that she did not recognize. She became very upset, immediately told her brother, who was walking down the hallway. He ran outside without really much of a description of who he was looking for, but he did locate a short distance away a black male who he did not know, who was in the neighbor's yard, and had a conversation with that person. That person claimed to be on the neighbor's property for a lawful purpose. The brother, not realizing that he was possibly speaking to the suspect, let the person go, and upon that person fleeing the scene, he noticed the person had a red collared shirt. And that brother would testify that it was not until he went back inside that he learned from his sister that the man that she saw looking through the window was a black male who was wearing a red collared shirt. Other witnesses from the house would have testified that they were running around trying to locate the person, that a black male in a red collared shirt came back to the scene and tried to retrieve a bicycle, which had been left on the scene as well. The occupants of the home would have testified they did not know this person, that he did not have any legitimate right to be on their property, and the court would have seen in court's exhibits aerial photograph that shows that this back window was well situated off of the sidewalk, and there should be no reason for any stranger to be back in this location. Police developed Mr. Cousar as a suspect. Following day, they brought back a photo array containing his picture, and the victim identified him as the person that she had seen looking through the back window. And again, they confirmed that they did not know him and that he had no legitimate business for being on the property. The state would have additionally presented evidence that Mr. Cousar, some 7 hours earlier, had bonded out of city court on a city court charge, wearing a red collared and striped shirt. And we would have offered some evidence regarding that shirt being very similar in appearance to the one the victim had seen. Additionally, we would have offered the testimony of an officer who recognized a prior encounter with Mr. Cousar, the bicycle that had been left at the scene as belonging to Mr. Cousar. That's the extent of the facts, Your Honor, and we have his prior record if the court would like to hear that. And I would like to state for the record, Your Honor, the reason for the negotiation of the 18 months was after a lengthy conversation with the victims this morning. We had been prepared for trial and ready to proceed to trial, and I know the defense had been ready as well. And the victim asked that we consider something that would help this case not go to trial. She just sincerely did not want to testify.
The allegations, those are the allegations as we understand them. Certainly would have had some issues pre-trial and with the testimony of the witnesses. I believe that the negotiation in this case is appropriate given the stance of the victims and witnesses. and given the time that he has served since June the 6th, I think it's an appropriate sentence. Mr. Cousar was willing to agree to that. I would ask the court simply to follow the negotiations in this case.
All right, I find the negotiations to be reasonable. And Mr. Cousar, on indictment 14 GS 463106, I sentence you to 18 months in prison. Credit for your time served from June 6, 2014. Good luck to you.
Thank you, Your Honor.
Thanks, Your Honor.
All right.